Without a requirement for corroboration, you cannot have a high bar for standard of proof. There is a general perception put out there, even by attorneys, that when it comes to sexual assault cases, the standard of proof is higher in criminal court than it is in a civil case. A civil case is pursued when a plaintiff seeks monetary damages. A criminal case is pursued when a complainant seeks a criminal conviction. Sometimes, in sexual assault cases, accusers seek both civil and criminal avenues, and legally are allowed to, in order to inflict maximum pain against the defendant and to seek maximum monetary compensation to ensure they never have to work again. Typically, the root of these claims is that the alleged abuse perpetrated against them, whether a one-time incident or during a span of their childhood, rendered them unable to pursue their career dreams because they had fallen victim to drug or alcohol abuse as a result of the alleged sexual misconduct. Though I find that in criminal cases, those points are usually left out because they are not relevant to the alleged incident at issue. In contrast, in civil cases, the most money is awarded depending on how good of an accountant you hire to draft a table of potential earnings you would have made in your desired career path if only you were never sexually assaulted. In both legal arenas, civil and criminal, there is no requirement for the accuser to independently corroborate their claims. This is true for most Western society legal systems, including the U.S. Here in Canada, legislation was passed in the 1980s to repeal a corroboration requirement where a judge would have to caution a jury that it would be dangerous to convict solely on the uncorroborated word of a complainant. As a result of this disastrous repeal, the criminal justice system encourages and facilitates vulnerable and opportunistic men and women to lie. While many innocent people go to jail and end up on the extremely ostracizing and intrusive sex offender registry for the rest of their lives, these innocent people and their loved ones are also vulnerable to vigilante acts of violent aggression, sometimes as far as murder. With this level of severe danger, loss of liberty, security, and the imposition of restrictive conditions, one would expect that the criminal justice system would take great care in ensuring that an innocent person is not convicted. Members of the legal industry, legal professors, media, activists, etc., will sing this caveat till the cows come home to assuage the general public that justice is always seen to be done, and that criminal courts have a much higher bar of proof than the civil complaint system. Well, that's a blatant lie. The criminal justice system and civil system are on equal ground when it comes to sex assault cases, and they have been ever since the 1980s, when the corroboration requirement was repealed. To prove my point, I present to you a quote direct from a 2008 Supreme Court of Canada decision. I provide the link directly to this judgment in the description bar below. Here is the quote. While it is helpful and strengthens the evidence of the party relying on it as a matter of law, in cases of oath against oath, there is no requirement that a sexual assault victim must provide independent corroborating evidence. Such evidence may not be available, especially where the alleged incidents took place decades earlier. Also, incidents of sexual assault normally occur in private. Requiring corroboration would elevate the evidentiary requirement in a civil case above that in a criminal case. Trial judges faced with allegations of sexual assault may find that they are required to make a decision on the basis of whether they believe the plaintiff or the defendant, and as difficult as that may be, they are required to assess the evidence and make their determination without imposing a legal requirement for corroboration. The smoking gun in this line is right here. Requiring corroboration would elevate the evidentiary requirement in a civil case above that in a criminal case. This is the Supreme Court of Canada, Justice Beverly McLaughlin, now retired and peddling her book, telling us that neither civil nor criminal cases require independent corroboration. And to require it for civil cases would elevate that standard to a higher standard that does not currently exist. What she's not saying is that at one time we did have that system, but feminist legal organizations tore it all apart for their own self-serving interests, and they are still doing it today. I reiterate, this is saying a whole new type of legal arena that currently does not exist would have to be developed with a higher standard of proof in order to ensure innocent defendants are never wrongly prosecuted and convicted. Until then, innocent defendants will be routinely wrongly convicted, and you can check my database for cases that I have curated that illustrate what it looks like to be convicted on uncorroborated claims. To conclude this video, my call to action for you is to spread this video around in the context of our criminal justice system endangering the lives of innocent men and their families when a sexual assault allegation is launched. I make a call to action to police services to recognize that they are the first line of defense for the innocent accused, and that they must take extra care when considering to lay charges in uncorroborated claims of sexual assault. Police officers need to go that extra mile to properly investigate the veracity of a complaint, rather than simply acting as an instrument that records complaints, passing it on to the prosecutor's office, leaving it up to them to toss a coin. My final call of action, write to your local MP and ask them if they will consider this extremely important problem in their campaign plans.